Chair.
Is everybody ready? Let's try this again. Please reserve your comments to what is before us so that we can allow this procedure to move forward smoothly. Comments were taken in relation to the Attorney General's amendments at Clause 4. The Attorney General responded, and further comments were taken. I'm now going to move forward. I am now going to move forward. I think the Attorney General has made his comments in relation to the comments that went prior. I'm now going to move forward with the amendments as put forward by Senator Drayton. Senator Drayton.
Thank you, Chair. I am suggesting that we insert, and this is based on Senator Richards' comments and the debate regarding technical assistance to be provided for MPOs to bring them up to speed with compliance. And Clause 8, there's a typo. It's Clause 8.3i of the FIU Act speaks to the FIU providing assistance to financial institutions and listed businesses in connection with their obligations under the Act. What I'm suggesting is that we add C to Clause 4, and it reads, provide technical assistance for nonprofit organizations to ensure compliance with the Financial Intelligence Unit Act of Trinidad and Tobago. And this may require an amendment to Clause 8.3i of the FIU Act, which only referred to financial institutions and businesses.
It says 4. 3?
Sorry, Clause 8.3i.
It says 3. It says 4.
Yes, there's a typo there. So it's 8.3i. Okay? Apologies.
You're finished, Senator Drayton?
Yes, Chair.
Attorney General, when you're ready.
Sure. I thank the Honourable Senator. Spot on. Nail on the head. But we caught it already. And I'll explain where. The bill itself asks for consequential amendments to the Proceeds of Crime Act. And if I can take you to the forgive me, let's get to the Proceeds of Crime Act. Page 23 of the bill. We actually amend the Proceeds of Crime Act to make an NPO a listed business.
Okay.
So it's caught right there. So I, in the FIU Act, applies to financial institutions and listed businesses. Listed businesses under the Proceeds of Crime Act mean all those entities in the first schedule to the Proceeds of Crime Act. So we amended here at clause, in the schedule, we've amended, at page 23, you'll see we're amending the first schedule by inserting a non-profit organization. So it's caught.
Thank you.
Thank you, H, and I agree with that because, as Senator Drayton said, it followed through my submission in the debate. And this covers those that will be supervised by the FIU over the $500,000 benchmark. Thank you.
Yes.
Thank you.
Nothing stops the FIU, as it does, from going about looking at concepts in general. So very often the FIU comes forward to any government and says, look, we think there ought to be some tightening because there's a constant continuing education on the part of the FIU. They sit on the National Anti-Money Laundering Committee. We legislated that committee in law under the Anti-Terrorism Act just last year. As part of that, they sit in all of the cycle equations for the Financial Action Task Force and at the Egmont Group. And at the Egmont Group, which is the expert grouping of financial intelligence units, they broaden out. So they really do have an ability of their own motive, on their own motion, to step forward and say, look, we want to regulate more. Then Parliament is asked to consider that by way of a minister proposing amendments to be moved.
Also, because the intention is to, while we regulate this sector, ensure that we provide support and the sector grows in an orderly manner.
Yes.
Does that exclude those that are registered but do not fall under the remit of FIU supervision? Can the FIU also include those in any way under the stricture of the law?
No, technically they go for who they are targeted to go for, but when they think that they're ready to go for more, we amend the law. And I really want to thank Senator Drayton for bringing home in this proposed amendment a very important concept for the public who's watching this debate, forgive me, who's looking at this committee. Section 8 of the FIU legislation says that the FIU has a positive obligation to help people to comply with the Act by providing the kind of assistance specified in subclause I.
Okay. Senator Drayton, in light of the comments by the Attorney General, are you inclined to withdraw your proposed amendment to clause 4 then?
I am, Chair. I'm satisfied with the
So withdrawn.
comments.
Honourable members, the question is that clause 4 be amended as circulated by the Honourable Attorney General. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Honourable Senators, the question is that clause 4 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 4 as amended now stands part of the bill.
Clause 5.
Honourable Senators, the question is that clause 5 stand part of the bill. Attorney General?
Mr. Chair, thank you. We received a submission coming from the Friendly Society asking us a very real and pointed question that we quite frankly did not consider. So I wish to thank the Registrar of Friendly Societies for bringing it to our attention. Friendly Societies are a bring over from a time past where they served a great purpose, in particular after World War II, in Trinidad and Tobago, and correct? And they are very much still alive, and they also have obligations for resources under the passion of the Minister of Labour, Mr. Chairman. The Friendly Society got an uplift of energy that it has never had before. We've been seeing their assets handed over to them, their positions gone forward. But when you look to what the definition of a friendly society manages, the pot that it manages, it falls within the NPO sector. They're already regulated under a different regulatory regime, and therefore it is quite proper to exclude them from the provisions of this. We did not, for instance, deem them to be NPOs as we have under Clause 8 of this bill. So it is proper in those circumstances for us to exclude them, and therefore we recommend an amendment to Clause 5 in the manner circulated, which proposes an exclusion for the friendly societies.
Okay. Honourable members, any? Senator Mark?
Mr. Chair, as it relates to Clause 5 and subclause 4, we find, given the commitment and reference made by the Attorney General to the Cayman Island legislation, we find subsection 4 of Clause 5 is a bit too onerous, Mr. Vice President. I'm talking about Clause 5 and subsection 4. In the Cayman Island, they simply ask, as it relates to NPOs, for item Roman 1, they deal with Roman 2. They would deal, Mr. Vice President, with but they have the identity of the person who owns or controls or direct the organization and the date of its registration. All of these provisions that are contained here, we find they to be oppressive, and we don't understand why we are trying to tie the hands and feet of the non-profit organizations. And if I am to take from the AG submission in the other place, where he said that the model that we are basing this legislation on is the Caymanian model, then I'm saying there's inconsistency with what is in subclause 4 of clause 5. And we do have reservations over this provision. We are also concerned about this imprisonment of 7 years. We believe that, Mr. Chairman, that there should be only administrative penalties. No NGO official should be subject to jail when they are doing voluntary service, Mr. Chairman. And you know, as you are aware, you are not being paid. It is out of humanitarian purposes. You come out there to serve, Mr. Chairman. So for you to come out there and serve on a voluntary basis and be subject to 7 years in jail, that is totally unacceptable. So I'm saying, Mr. Chairman, in winding up, that when I look at the Caymanian legislation, they deal with administrative penalties, which deals with only cash. And the maximum is 3,000 US. So I don't think we can support this 7-year arrangement here whatsoever.
Me?
Mr. Chairman, I was concerned about the subsection 2, the fine of $50,000 and the imprisonment for 7 years. I know the AG had said in his submission that he was going to make these fines not as punitive, but I'm looking at this in relation, this is if you shall operate, if you're operating here without registration, which is separate from what I think the Attorney General has spoken to before about if you administratively didn't submit your papers and stuff like that. Is it there, Attorney General, that you're going to change those fines? That, or, because this is, I think it's still punitive.
Senator Vera?
Thank you. I understand the concerns both by Senator Remy and Senator Mark, but this section is relatively clear. You can operate. What it is saying is, if you want to operate, you must register. The registration is not an onerous requirement, and I think if you are going to be serious about regulating the sector, there must be a sanction for operating without registration. So I have no problem with this section. I paid very careful attention to Senator Baptiste Primus when she was making her contribution. This is on the AG's amendment. And she spoke about friendly societies, fraternal orders, cooperatives, and credit unions. Now, I know all of these friendly societies, cooperatives, and credit unions have their independent legislation. Why only exempt the friendly societies and not also include the cooperatives and credit unions?
Senator Obika.
Thanks, Chair. I just want to submit that regarding the clause that we are on, when you look at even the cases put forward by FATF, the penalties in some of these jurisdictions are to the institution, to the NGO, not to the persons. So the ultimate penalty in the case of a registered NGO is deregistration. In the case of one that is not registered, all right, it can be that one that is not registered, the penalties are imprisonment. I think that it should be removed entirely. And just to add some value to Senator Vera's query, given it's for the Minister of Labour, if I may, I think the reason why credit unions aren't captured is that credit unions are regulated under the Ministry of Labour by the Commissioner for Cooperatives. This is a department I worked in for 4 years. And the regulation is very rigorous and it's very detailed. And I don't think they need to be part of this bill.
Senator Thompson, aye. I know, please, yeah.
On that same clause, but not on that same point, the 5.1, clause 5.1 shall not operate a non-profit unless the non-profit organization is registered under this act. I would suggest that the transitional provision be brought nearer to it, as happens in the, last week, it seems like last week, a few days ago, I spoke of the community residence and foster care act. I think that's why 3 of us were sitting together and we missed it completely. And I'm wondering if Senator Drayton's amendment is because he missed it as well. You see? So if you have the provision here where you have to be registered within a particular time, brought nearer to this mandatory provision for registration, I think it would be a smoother flow, it's a more logical sequence to me. That's
Okay,
my
so
suggestion.
let me allow the Attorney General to respond, given the number of comments that have come before. Attorney General.
Thank you, Mr. Chair. I confess sometimes it's hard to keep a track, and I don't want to do an injustice, so thank you for recognizing that. Mr. Chair, where do I begin? With respect to the offense, Senator Mark's first point, could I just ask Senator Mark to refresh me as to what his first point was? I got his comment on the offense, and then I got Senator Remy's position on that. Senator Mark, through you, Mr. Chair, would you remind me what your first observation was?
Is that when I looked
Oh, Caymanian, I remember now.
Yes.
Okay, if I may. Thank you for refreshing my memory. Mr. Chair, the Caymanian model, which is the Non-Profit Organization Law 2017, Law number 37 of 2017, actually has a much wider and more intrusive form and detail of registration. Let me read it for the record. You are, for the purposes of registration, to submit declared purposes of the NPO, identity, address, other contact information of controllers, senior officers, members, management personnel, copies or particulars of trust, trust deed, any other organizational document, copies of the Constitution, memoranda of association, articles, etc., information with respect to the location of the money and other property of the non-profit organization and its banking arrangements, the source or anticipated source of contributions, how contributions are to be applied, and, listen to this catch-all, any other evidence which reflects the organizational structure and functions of the non-profit organization. Now that is by far wider and by far deeper an intrusion into what we define as sensitive personal information under the Data Protection Act. And for those reasons, we took the opposite approach of what Senator Mark is saying. We did not go as far as Cayman did. We actually stayed much narrower in purposes. So I want to just distinguish that immediately by saying that the government's approach is by far safer than the Caymanian approach. In any event, we did not want to go into 3/5 issues of sensitive personal information being provided in a public record, even though that could be kept disaggregated between regulator and public aspects, as the bill proposes. With respect to the offense, both in response to Senator Remy and to Senator Mark, I thank Senator Vera for putting it much better than I could possibly have. He was very succinct in it. Law requires a sanction. A sanction must be certain. If we have loopholes, then you create a lack of compliance. What we did inside of here is that we treat with the exceptions to the law a little bit later. And as we come to section 23, clause 23, you'll see where we're proposing exceptions for one-off occasions, etc. So we respectfully must draw a line. As to the level of sanction, we took our position, fine of $50,000 and imprisonment for 7 years. I want to inform, of course, the law is that these are just maximum statements. It isn't that they are applied automatically. It's open to the court in considering any matter to have this matter treated with in a lesser fashion, including the fact that there may be no charge, monetary sum paid, or no jail term imposed. So this is just a statement of the maximum that the law can offer. The transitional migration, because the transitional law is there, it's a feature of the architecture of the drafting of laws that you put the transitional towards the end, because the Act is arranged in parts. And when we look to Part 2 is the supervision and registration of non-profit organizations. So it's when we get down past Part 3 and we get towards the end of the bill, transitional provisions are, as a matter of course, usually put there. And that comes under Part 5, miscellaneous. So the drafting experience and the consistency of Trinidadian laws requires us to put it down towards the end. I'm guided by the CPC's department in that regard. I'm constantly reminded by them that I'm not drafting a contract. If I could draw it in contractual terms, where you would usually say, you know, subject to clause X of X position, this then applies. So I'm guided by the CPC's department and the experience of law in this country, and I would respectfully ask you not to urge the moving of the transitional provision to this clause and to keep it where it is.
The drafting of laws in this country, and the laws I refer to is an act which is drafted in Trinidad and Tobago,
Sure.
and that is where it is.
Yeah.
So I mean, it's entirely up to you. But
Well,
it seems to me to be a more logical place to put it.
I also had the fight
And
with the
there's
CPC's department on risk-based.
Yes, I spoke to them during the break about that.
Yeah.
I told them I was allergic to bad grammar.
You and Senator Prescott from his last incarnation.
Oh, yes. I remember the Adoption Act, Mr. Chair.
You've completed the response to the first, I think, four senators. Senator Drayton, you had comments.
Sure. I agree that the maximum fine is and prison sentence of 7 years is just way too onerous, and perhaps the AG may consider reducing it to 3 years.
Let me put it to you this way, if I may. What happens if we're dealing with a $100 million entity? What happens if we're dealing with Red Cross? What happens if we're dealing with massive money? You see, this is a law for non-profit organizations. I can't say, well, for the $100 million guy, you get $50 million fine and 100 years imprisonment, and for it just becomes extremely difficult to draft law that way, which is why I put the maximum sentence and maximum conviction on the record, because a court in the administration of its functions and in its construction of law and consideration of the facts and law that it hears will decide what the appropriate penalty is. But our law just says that these are your ceiling limits. It's everything under that.
To Senator Drayton, through you, Chair. Let me share an experience, because I act for the dental profession. And the dental profession regulates dentists who are registered and dental auxiliaries. Quacks who are not registered are outside of its jurisdiction. So ironically, you could be setting standards and trying to discipline people who are compliant, and the people who most need to be reined in or to be helped fall completely outside your jurisdiction. And your only recourse there is to have some kind of stiff criminal sanction to say, you can't do that. And so that is analogous to the situation here. Because if you don't have that sanction, then why register? I'm just outside the jurisdiction, you can't do anything. You thumb your nose at the regulator.
Thank you. I actually was going to clause 3, so if you wanted to respond to Senator Vera, I would. I mean, sorry, part 3, under the section, subclause 3, on the form, yeah. So,
No, Senator Vera was assisting me. There's no response required other than to say thank you.
great, thank you. So it's just on the topic of the forms. I know it was raised during the debate, the prescribed forms. And so when would the NGOs be seeing the form, since it's not included?
I don't want to be churlish. I say this most respectfully, but when they're drafted, after consultation, so there's still a process to go for that. That's why we put in a proclamation clause in clause 2.
Sorry, I think in general, after the bill is passed, we're going out, the AG office is going out for consultation.
It always does with respect to proclamation.
If there are any amendments, you will come back to make
Of
amendments.
course, I give that undertaking on the record. And that is evidenced by the many times that I've done that. There have been times I want to remind the opposition where Senator Ramdeen has made very sensible submissions. I gave an undertaking to come back and amend the law, and I have kept that.
The forms then would come as attached if you have changes when you after consultation.
No, we're
with the
prescribing the
NGOs?
forms. They're not scheduled forms. The methodology of prescription for forms, prescribed forms, is so that they can continue to live and breathe without having to move the Parliament every single time to change the format or how many lines, etc. That became very unwieldy in
I
practice.
just wanted to know for
Yeah.
the record, right?
Senator Obika?
Thanks, Chair. Given the decision to keep this clause as it is in the bill, I think it would be incumbent on the government.
But we're
to-
not.
to
We're
educate.
proposing an amendment.
No, but I don't want the jail term, or
I
any
see.
jail term at all.
Sure.
I think it will be incumbent on the government to ensure that they spend a lot of money to advertise to the public, because persons would not be able to join any group that does anything without being registered. So you must tell the population that they cannot join a group to raise any funds for any beach cleanup. They cannot join a group to help any sporting organization. That they cannot join a group, as I have, to help their primary school, because they will be jailed simply by being part of an NGO that is not registered.
So, Mr. Chair,
Sir,
I must
AG, yes,
I must
respond.
reject that contribution because it's just not true. This law is only intended to catch the definitions of non-profit organizations, which are clearly grounded in the trustee-type relationship where the positions are managed. Furthermore, we propose amendments, as have been circulated in respect of later clauses, where you can do exactly that. So I just cannot accept the submission. But if I wanted to be charitable, I could say that there is merit in what Senator Obika has said. There must be outreach and training and sensitization. This has to happen. The government will be going together with the non-profit organizations and the network of NGOs. And I love that expression. And I want to single out Nicole Leoto in particular, who comes from the entity that she does, for being as strident as she is in her invitation that not only must be done, but in the willingness to accept the role to help in facilitating that. So there will be an aggressive outreach campaign. It will be very much high on agenda, not only from the government, but from the FIU as an independent regulator.
Okay, so moving on, Senator Drayton, you have proposed amendments on Clause 5. Do you want to make some statements?
Mr. Chair, sorry, I forgot to answer a very important question from Senator Vera, the cooperatives and credit unions. Would you permit me?
Sure.
The FATF rules do require credit unions and cooperatives to be regulated. The Minister of Public Utilities is actually the chair of a committee which the Cabinet has set up, and that is hard at work with the credit union sector in particular. It would not be surprising for me to remind you that the credit union legislation to reform itself has been in discussion for a small 28 years. Much like the Insurance Act in its most recent vintage took as long as it did. So the FATF does intend for the regulation of these entities because of what Senator Obika actually put onto the record, which was very helpful in echoing what the Minister of Labour put. They're managed in a different way. But they are going to be subjected to certain aspects of regulatory positions in this. So we did not intend to single them out in the fashion that we have for the registrar, as recommended by the registrar of friendly societies. So it was a very purposeful position on that. But we are intent, in fact, there's a policy paper already that the Minister of Public Utilities is in consultation over with these sectors.
So Senator Drayton.
Thank you, Chair. My amendment actually is addressed in 28, the transitional clause that Senator Thompson and I spoke about. And I was able to get a better appreciation from the AG in terms of the positioning of that clause. So it's addressed in 28. Yeah.
So you're
So
withdrawing?
withdraw, yes.
Yes, you're withdrawing. Okay. Okay, honorable members, the question is that clause 5 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Honorable senators, the question is that clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No, division on this one.
Senator Khan,
Yes.
Senator Gobiskun,
Yes.
Senator Batiste Primus,
Yes.
Senator Rambarat,
Yes.
Senator Sinanan. Yes. Senator Hussain,
Yes.
Senator West,
Yes.
Senator Lahan,
Yes.
Senator Henry,
Yes.
Senator Singh,
Yes.
Senator Cummings,
Yes.
Senator Dookie, Senator Simonette,
Yes.
Senator Thomas,
Yes.
Senator Young,
Yes.
Senator Mark,
No.
Senator Haynes.
No.
Senator Amin,
No.
Senator Hussain,
No.
Senator Obika,
This will end voluntarism. No.
Senator Ramdeen, Senator Richards,
Yes.
Senator Vieira,
Yes.
Senator Dial Singh,
Yes.
Senator Dionarine,
Yes.
Senator Sipasad,
Yes.
Senator Timal,
Yes.
Senator Thompson Aye,
Reluctantly, yes.
Senator Dylan Remy,
Yes.
Senator Drayton.
Yes.
So the result of the division is 24 members voted for, 6 members voted against, and there was 0 abstention.
Honorable senators, the results of the division are as follows. 24 members for, 6 members against, and 0 abstentions. Clause 5 as amended now stands part of the bill.
Clause 6.
Honorable members, the question is that clause 6 stand part of the bill. Attorney General?
Thank you, Mr. Chair. There are two circulated amendments, that for the government and that by Senator Drayton. And I think we actually captured the same thing. So if I could, in anticipation of hopefully his agreement, deal with both. Clause 6 treats with the power to grant or renew registration. And coming out of the debate and in the discussions with the NGO sector, there was a lot of merit in managing this in a slightly different way. We propose, Mr. Chair, that immediately after clause 6, subclause 2, that we insert a new subclause, and then we treat with some further amendments. So 6.1 is where the registrar is satisfied that an applicant has met registration renewal. He shall, and then he does certain things. And then 6.2 says the Registrar General may refuse to register or renew an applicant as a non-profit organization if, and then it sets out certain criteria. So we propose just after that we put in some due processing. And it would look like this in a new subclause 3, where the Registrar General refuses to register an applicant under Section 5 or refuses to renew an application under Section 7, the Registrar General shall, within 14 days of such refusal, issue a notice to the applicant and provide reasons in writing thereof. We then go on to subclause 4 to say, where an applicant receives notice under subsection 3, he may, within 30 days of the date of the notice, provide the registrar with written reasons as to why his application should be approved. And then we deal with a new subclause 5. Upon receipt of reasons under subsection 4, the Registrar General shall determine whether the registration should be granted or the renewal refused, and a notice shall be sent to the applicant accordingly. Now, we've done something which is a little bit exceptional. It's administrative law in proper context that when the registrar does something, that reasons must be provided. So we didn't rely upon that on an implied basis because of the sector that we're dealing with. We've expressly put that into the law that the registrar must give not only notice but written reasons as to what's going on in the registrar's mind. We agreed, coincidentally, as a result of the urgings coming from, who was it, Brianna? Today? We got an email just today asking us to go to 30 days. It was Colin Robinson from CAISO. Mr. Robinson recommended that we go to 30 days. We thought that that was eminently sensible. So we have harmonized the period for 30 days in terms of the reply from the applicant. And then we have said in that due process structure how we ought to treat with it. So that is in the round the reasoning behind our proposed amendments, Mr. Chair.
Sure. Senator Ramdeen?
Attorney General, I just wanted to ask, what is your view as to whether you think that even if the refusal is done, the extra duty that you've put to provide reasons, our experience in this jurisdiction has not been very good with the provision of reasons during a fixed time period. So, for example, we have 60 days for a magistrate to provide reasons under the Summary Courts Act, and I was wondering whether the notice should be given within 14 days, or whether we should give the Registrar General a little bit longer period of time than 14 days to be able to, for the provision of reasons. I think 14 days is a little bit short for the provision of the reasons, because I expect that the reasons would be in writing. It wouldn't just simply say it is deprived because of Section 10A, B, C, D, or whatever. They would have to extrapolate as to why it is that this is not done, and I just think from an experience...
I welcome the prudence of the suggestion, Senator Ramdeen. On the one hand, we were trying to make sure that the registrar acted quickly for people who were anxious, but there is eminent sense in what you're proposing.
That's what I'm saying. I'm saying that we should perhaps divorce the 14 days from the period of time for the provision of reasons, because one would want the decision to be done quickly, but the provision of reasons doesn't necessarily have to be within the same period of time. So I can keep the 14 days to achieve what you wish to achieve by virtue of putting it in. I hear you on the provision of reasons, but I think 14 days is a bit short. The Registrar General has a number of things that we are adding to on a daily basis. So I would suggest, I don't suggest that we go to 60 days, but I would at least suggest that we...
what is saying is, shall within 14 days as such issue notice to the applicant and provide written reasons within 14 days thereafter.
Okay.
Thank you. Mr. Chair, accepting Senator Ramdeen's submission, what could be open to us in the subclause 3 is to modify the language as circulated. So we could say the Registrar General shall, within 14 days of such refusal, issue a notice to the applicant. And then we could add in and provide reasons within 14 days thereafter. So what we could say, so we could issue notice to the applicant, shall within 14 days of such refusal issue a notice to the applicant and provide reasons in writing thereof within 14 days thereafter. That would catch the concept. Sure.
Because of the nature of the way in which legislation is drafted, which is that if you don't have registration, you're not supposed to perform any function. You will have cases where I can foresee that you will have cases where perhaps on a reconsideration of the reasons that are being provided by the NPO, that you would have a period of time, a subsistent period of time, where your application may be rejected. I'm speaking in terms of of staying that decision as to whether you want to give the Registrar General a power, because what would happen is that if you're rejected, you should stop conducting any business. You then go into a stage where you have this reconsideration period, in inverted commas, like an appeal period, where your application is going to be subject to a review during that period of time. Would you want to consider that some organizations may suffer some degree of hardship during a period of time where, by the law, they're not supposed to be conducting any business, but they may well be found to the Registrar General may well be found to have not exercised the discretion or power properly, and therefore they would then be reinstated then, if you want to put it that way. It's a matter of policy for you as to how you wish to treat with it. But I could just see that that situation may arise that can cause some hardship to a particular organization.
So, sorry?
When I proposed this amendment, it was because you actually have in the legislation specific instances for cancellation. So it's not a case where the Registrar General is going to look for reasons. My concern was that it was not stated. And all these are very specific, and I think what should happen is automatically when you're canceling, that you write it there. It's not so, you don't really need time, because when you come to that decision, you come to that decision based on these specific, what I call the unlucky 7 on the last occasion. So that I don't think the time factor is really important here for this part of it.
Senator, before you answer, Attorney General, Senator Vera.
Thank you, Chair. I think the purpose of this clause came out of one of the suggestions from the opposition about avoiding having poor people to find lawyers to go to a judge in chambers, to go to a judge to appeal. And so the idea was to give a first stab by dealing directly with the Registrar General. I take what Senator Ramdeen has said, and I was wondering whether we could perhaps have done it a little differently, that the decision of the tribunal not to renew, he issues the notice, and the notice should contain reasons for the decision. But if the tribunal, if the registrar does not state its reasons for the decision or order, then the applicant can serve a notice on him, requiring him to provide reasons within a certain time. And so that could deal with the time constraints.
The lawyers and all of us are coming to the front because we like to due process everything out in meticulous points. So the suggestion came from the NGO sector itself, the NPO sector. Secondly, the model for treatment came from the Companies Act. Thirdly, cancellation we treat with entirely separately. I agree with Senator Thompson-Nye. Under Clause 10 is where we treat with cancellation, but cancellation is not to be conflated with renewal or application on an initial basis. The disaggregation of decision and reasons is somewhat problematic. We could probably fix that if we were to just put a plain 30 days. And probably we can fix the standstill, which is essentially what we're talking about, by treating with that in a very simple way, which is to just simply say that the decision shall not be conclusive until the last step is really had, which is where we come down to the subclause 5. Upon receipt of reasons under 4, the Registrar General shall determine whether the registration should be granted or the renewal refused. But in saying that, I would say that it is not until the completion of steps 3, 4, and 5 that is actually de jure a refusal. So the process must be had. So even though the notice goes out saying, look, I'm not renewing you and I'm not going to grant you your first time, it's not a binding decision until clause 5, subclause 5 happens, which is where the tribunaling or administrative routing happens. So if I may therefore in summary suggest, so as to avoid the position, what we could do is to accept Senator Ramdeen's position as I now interpret it. So forgive me if I've done an injustice to what you've said. In subclause 3, we just add the words within 14 days thereafter to the end of that. So that means you get your 14 days notice. You know it's not going to happen. The reasons come within 14 days thereafter. They may come simultaneously or not. But I'd be comfortable with the fact that it's not until subclause 5 happened that the decision is in fact, by way of the operation of the law, effective. So may I just therefore recommend the addition of those words into the government's proposals as circulated.
Okay, so, Senator Ramdin?
Okay. Thanks.
Attorney General, the subclause 5 would. Sorry. Attorney General, sorry, what do you, I'm just not following the last thing that you had said about the subclause 5. That subclause 5 is found in your amendments?
Yes, it's on page 2,
I'm sorry.
on the top of page 2.
On the register, the register will be granted or refused. And you're saying that it shouldn't be effective until 5 is carried out? Yeah, I agree with that.
Thank you.
Okay, Senator Drayton, you had proposed amendments to clause 6. Are you, based on conversations thus far, inclined to withdraw that, or?
Yes, Chair, the Honorable Attorney General beat me at it. So,
Okay.
yes.
Honorable members, the question is that clause 6 be amended as circulated and further amended to say at new subclause, after subclause 2, new subclause 3, at the end, within 14 days thereafter. Attorney General, is that correct?
Just delete the word thereof, I apologize.
Deleting the word
So
thereof
delete the
prior
word
to that.
thereof, and then within 14 days thereafter.
Okay, so let me just read that again. The question is that clause 6 be amended as circulated and further amended after subclause 2, the new subclause 3, at the very end, delete the word thereof and add the words within 14 days thereafter. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 6 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 as amended now stands part of the bill.
Clause 7.
Honorable members, the question is that clause 7 stands part of the bill.
Mr. Chair, the government has proposed
AG.
an amendment to clause 7. We accept that the 3-year period may be too tight, and therefore we propose that the re-registration ought to be at 5 years instead. Of course, we welcome views on this particular period.
Senator Mark.
Mr. Chairman, I wanted to ask whether companies for profits in this country, are they given a stipulated time period? And why are we imposing on these ordinary people's organizations a time frame? Because you remember, Attorney General, you did make reference to the Cayman Islands, and they, even though, as you said, they are very strict, and we have backed off on many aspects of what they have in their legislation. When I go, Mr. Chairman, to clause 7, subsection 4 of the Cayman Islands legislation on non-profit organizations, it reads, a certificate of registration issued under subsection 3 shall have effect indefinitely. So in other words, once an NGO registers with the Registrar General's office, it is left up to the state to monitor this NGO. But why are we having them straight to the Registrar General's office every 3, well, now it's to 5 years, to have a renewal and have an axe over their heads? I do not support, and we do not support this time stipulation. We believe that it ought to be an indefinite period. Once you register, Mr. Chairman, it should be for life, and it shouldn't have to be going through. Because you see, already you're putting it in the hands of a bureaucrat, the Registrar General, a lot of power to determine the faith of these NPOs. And I do not believe that this is fair. So I would suggest that we consider going the way of the Cayman Islands and have an indefinite period of registration. Once you register for life.
Any further comments from members? Senator Vera?
Thank you, Chair. I understand the sentiment, but, and I could be wrong on this, but I thought that in the case of the profit companies, they have a requirement every year to file annual returns. That is not visited on the non-profit organizations. And so 5 years gives a lot of time to see whether you're still operating or not.
Yes, one comment with respect to Senator Vieira's comment is that the bill will also capture those non-profit organizations that are incorporated as companies under the Companies Act. Now, those companies are required to file an annual return also, Mr. Vice President. Mr. Chair, Vice Chair. So I don't know whether or not the point that Senator Vieira has made, it will make a distinction with respect to those that are incorporated and those that are unincorporated under the Companies Act.
I thank both senators. Mr. Chair, Trinidad and Tobago's context must be considered as Trinidad and Tobago's context. So it's true that Cayman has indefinite registration, but it's true that BVI has a registration for 1 year. So different jurisdictions have different standards. Secondly, yes, it is true that nonprofit organizations file a Form 29 under its obligations under Part 5 of the Companies Act on an annual basis. But it's also true in the Trinidad and Tobago context that we have 104,000 companies and 25% of them are in terrible arrears, and people find themselves in a dramatic situation where those companies can't be brought up to date until they take expensive steps like paying hundreds of thousands of dollars in penalties that have accrued over years. I'd go further. To drive a car, you have to have a license which is renewable. A passport is a license which is renewable. A liquor license to sell alcohol is renewable. So the concept of a limited time frame for regimes is an important one. In the nonprofit organization sector, we propose this because of the analysis of the Trinidad and Tobago context. So in the round, therefore, Mr. Vice President, we think it's a safe mechanism which will assist nonprofit organizations. And what I can tell you from an operationalization point of view, the Registrar General's office is about to receive a significant facelift from an IT perspective. We have procured new software and new servers, which are of significant importance to the operation of this. People will be receiving electronic reminders. They'll be receiving notifications that are automatically generated. They will also, hopefully by the course, if not this month, by next month, be able to do all their filings by way of electronic payments and filings. This is not in the distant future. This is as close as next month. And there are very robust entities that offer a range of services in this regard that the government has already put to use. First Citizens Bank, WePay, there are lots of providers and platforms for these services, so we're very close at hand. We think it a safeguard to take the nonprofit organizations out of that hundreds of thousands of dollars pot of trouble that companies find themselves in under the company's registry.
Thank you. So, AG, I think this is an important point for a lot of the NGOs because they were inquiring whether or not it would have been possible for online registrations and certifications. And again, that they will not be subjected to filing these annual returns.
Correct. But Senator Hussain was correct. The nonprofit companies continue to comply with the Form 29 requirement under the Companies Act.
Senator Obika?
The question I have has to do with, when you get questions from the public, right? It has to do with PAN sites. Does this legislation capture steel pan organizations? And how, given this particular clause, the ability of the Registrar General to refuse registration, if a pan site is registered with Pan Trinbago, would the Registrar General be allowed to refuse them to register? That's the question.
Attorney General.
If a pan site falls within the definition of charitable and other purposes as defined in the trustee type relationship, well then yes, they'd have to be so defined. But pan sites aren't necessarily that. It depends upon how they structure themselves. So if pan sites are engaging in non-profit type of behavior, yes, but that's a very limited description. They have to be engaging in something where they are not benefiting for themselves to do something. So for instance, a commercial pan site, which is going out and playing and paying and receiving money, etc., and then their members receive money, well, they're not a non-profit organization, because the exclusion for a non-profit organization is that you cannot be doing this for the benefit of your members. So there's a very careful description as to what constitutes a non-profit organization. So if you're in the business of doing something for the benefit of your members, you're not a non-profit organization.
Senator Obika.
Chair, however, that is in conflict with the explanation clause, I think clause 3, which states on the non-profit organization, there's
Page 4 and 5 of the bill.
on page 5 at the top, it carries up, subsection B, carries on its business without pecuniary gain, except as reasonable compensation for services. National Center for Persons with Disabilities, for example, have on their role staff, they have a CEO whose salary is in excess of $15,000, significantly more than that, but I don't want to quote the actual salary. So I'm saying, are you saying that the NCPD is not a not-for-profit?
Well,
that can be true. So the point I'm making is, a lot of pan sites provide compensation for, under this clause, reasonable compensation for services rendered. If someone is a pan tuner for the side and a ranger for the side. So the question still stands. If Pan Trinbago sends their full list of 100 plus steel bands, is any one of them going to be debarred registration?
AG.
Mr. Chair, we could intellectualize and find fine-tooth descriptions based upon facts which are all hypothetical right now. This thing will have to be judged upon the case-by-case analysis of the facts. I mean, Senator Obika started talking about pan sites and then went to a completely different type of structure, which is not a pan site, and then came back to pan sites. So the point is, if you fall within the definition of a non-profit organization, yes, you will be registered. Filling out that paperwork is not a hard thing to do. There will be outreach, there will be sectors, etc. But the definition of an NPO is, it's established for promotion of patriotic, religious, philanthropic, charitable, educational, cultural. Yes, okay, I can read, Senator Obika.
Okay.
And then you carry on its business without pecuniary gain to its members or officers except as reasonable compensation. And it restricts the use of any of its profits or other accretions to the promotion of its purpose or objects. So if somebody falls within that definition, yes, you're going to be registered. And then, so what?
Okay. Senator Mark, you had...
Just wanted to get clarification, Mr. Chair. Mr. Chair, under, and this is for the AG consideration, under clause 7, subsection 2 and 3, the AG, like myself, believes in due process. And we have a situation here, Mr. Chairman, where the Registrar General will be making rules, including determination of fees that these non-profit organizations are called upon to pay. But these rules are not going to be seen by the Parliament. According to what I have read in the document or the bill, the rules are going to be submitted by the Registrar General's office for the approval of the Attorney General. I find this a bit unhealthy because we are passing legislation to prescribe rules. But after we pass these rules, Mr. Vice President, in terms of giving the Attorney General the power to make these rules, we do not see sight of these rules it is being kept secret between the Registrar General's office and the Attorney General. So what is the role of the Parliament? The Parliament should have sight of what fees and other rules are being advanced. And I'm asking the Attorney General that that be subject. I like affirmative, but I would ask him, in the interest of transparency, he can even go for negative. But at least there must be some oversight by the Parliament of these rules.
Attorney General.
Mr. Chairman, the Registrar General's Act of Trinidad and Tobago is an Act of Parliament, 1903. It was promulgated in the year 1921. And since this Act came into effect, the ability to make rules is expressly provided for at Section 10 of the Act. And Section 10 of the Act provides that the Registrar General shall make rules, etc. Since 1921, straight up to today's date in 2019, nearly 100 years later, 98 years later, no government has come to amend the law to say make rules subject to negative or affirmative resolution. For the record, the rules are continuously made by the RG, and they are a bare pittance. It's $25 to file a name search and name reservation. $25 doesn't even buy a coffee in some places. So we're confident that the robustness of the 1921 Registrar General's Act can take care of this.
Mr. Chair, just briefly, I understand what the AG is saying 99 years ago. I wasn't around. I am around now. And I am suggesting, Mr. Chairman, that we take into consideration the current reality. Mr. Chairman, if I may invite you to go to 27(1) of the Act. They are formulating, they are establishing forms, they are determining fees, Mr. Chairman, and other matters relating to registration, and we have no sight of that. Mr. Chairman, that can't be fair. So if that was a relic of the past, why must I continue with that relic? And I am sorry that if other governments overlooked it, but I am not overlooking it.
I think I get the gist of what you're saying, Senator Mark. Attorney General, not to preempt you, I assume that you're going to make the same response. Right. So those are the comments in relation to this particular clause. I shall now put the question. The question is that clause 7 be amended as circulated. Those in favor say aye. Those against say no.
No.
I think the ayes have it. Honorable Senators, the question is that clause 7, as amended, now stand part of the bill. Those in favor say aye. Those against say no.
No.
I think the ayes have it. Clause 7, as amended, now stands part of the bill.
Clauses 8 and 9.
Honorable Senators, the question is that clauses 8 and 9 stand part of the bill.
Wait, I just want to, the clerk just rushed. I know that we were going clause by clause, but I don't know if this is a special one that she's connecting. But I don't want it to become a habit on the part of the procedure, because you have established a procedure, clause by clause. So if you go in clause by clause, 8 and 9, next thing I'm going 10 and 11. I don't want to go there. Let us go clause by clause. No, I'm proposing what the chairman has said. The chairman has said we're going clause by clause, and I'm just saying let us keep to that rhythm, clause by clause. We may not have any objection to this, and in 2 seconds it's gone.
Remind you can speak to both clauses.
No need to respond, Attorney General. Let me respond. The question is put to me. So what's happening here is that there's no written amendments put forward to clauses 8 and 9. So the reason we call clause 8 and 9, and as you well know the procedure, there's a slight pause to allow members to make any comments in relation to both. So again, clause 8 and 9, the question is that it stands part of the bill. Any comments? No comments. Honorable Senators, Senator Mark, let me put the question, please. The question is that clause 8 and 9 now stand part of the bill. Those in favor say aye. Those against say no. I think The ayes have it. Clause 8 and 9 now stands part of the bill.
Clause 10.
Honorable Senators, the question is that Clause 10 stands part of the bill. Attorney General.
Mr. Chair, the government proposes that we do some tidying up to Clause 10. The tidying up which we do relates to Clause 12, and it really is where we allow in Clause 10 cancellation in Clause 10(1)(g) to be done on the recommendation of the regulator under Section 12. That Clause 12 is dangerous when we had a second look at it, because when we massaged it and we had a proper scrub look at it, Clause 12 effectively allows the Registrar General the ability to cancel a registration before the FIU has finished its administrative run under the Financial Intelligence Unit Act. So of our own volition, without anybody noticing this, we had proposed that we delete Clause 12. It's the government's recommendation. No stakeholders referred to this. Nobody in the debate referred to this. But on my second reading with our team, we felt that we should remove Clause 12. In those circumstances, it's effectively a consequential amendment to Clause 10, that when we delete Clause 1(g), that we would have to move the word "or" into the subclause above and just adjust it. So this is really in contemplation of the recommendation for the deletion of Clause 12.
Okay. Senator Mark.
Mr. Chairman, again, we have some reservation about the Registrar General having this power to cancel registration of nonprofit organizations for the reasons outlined in this section. And we had indicated that it is Caesar speaking to Caesar, meaning that the Registrar General has the power to cancel. But what is being advised as we go along in the future, reasons can be proffered as to why they are canceling. But the determination for canceling remains in the hands of the Registrar General. I think something is wrong with that process. There's no arbitration. There's no independence. There's one body that is telling you, Mr. Chairman, are canceling, are giving you reasons, you object, I object. And when I object, you will then determine for me whether I will be canceled or not. This cannot be fair. This is an unjust provision. And therefore, that is why we had argued that we needed a tribunal to intervene in these matters, where, for instance, there'll be some justice and fairness in the process. This is going from the Registrar General back to the Registrar General. So we find this to be a bit onerous, Mr. Chairman, and we'd like the Attorney General to revisit this provision.
Attorney General.
Thank you, sir. May I just start off by saying everything that Senator Mark just said is wrong. Completely and totally wrong. And it's wrong from a plain reading of the clause. Let's go to what Senator Thompson-Aye called the 7 deadly sins, now the 6 deadly sins. Listen to subclause B. The Registrar General may cancel the registration of a non-profit organization. Senator Mark just said Caesar unto Caesar. So let's look at if Caesar is talking to Caesar, right? B, it is proven in a court that the non-profit organization breached a duty owed to itself or any of its contributors. C, it is proven in a court that the non-profit organization committed a criminal offense which carries a penalty of a term of imprisonment 3 years or more. D, the NPO is found guilty of an offense under the Proceeds of Crime Act, Anti-Terrorism Act, Financial Intelligence Unit Act, or any other written law by which the recommendations of the FATF have to happen. That's a court. E, the non-profit organization is a designated individual under Section 22B of the Anti-Terrorism Act and the Economic Sanctions Act. Section 22B requires listing before a High Court judge in a court of law after an application is made and publication is had. It is a court of law that does that. F, the non-profit organization is struck off the company's register under 461 or 489 of the Companies Act. That's the Companies Act. A, the one I left for last. The non-profit organization failed without reasonable cause to keep financial accounts or records within Section 14, or to submit audited financial accounts and records in 15. So let's deal with Roman 2. Who gets the reports and then says that you failed to submit? The FIU. How does the FIU operate? Section 18G of the FIU Act. They have to go through an entire administrative process, which requires them to tell you you breached, call upon you to do something, give you the opportunity to do it. If you don't do it, they go to court, they get an order of the court tells you to do it, the court then warns you, then the court sanctions you. So, Mr. Chairman, where does Senator Mark get this from?
I'll clarify for you just now. Mr.
Respectfully.
Chairman, can I clarify?
Respectfully.
Yeah, let me clarify. Mr. Chairman, what the Attorney General has said, in 10.1 A and B, the Registrar General has the final say in this matter, right? We have said, and the Attorney General is only supporting what I'm saying. When you go to B, C, D, and E, Mr. Vice President, in the case of, let's say, B, where it is proven in court, Mr. Vice President, you have a right under this law, once it is proven in court, right, to appeal. That there's a provision in the law that talks about appealing. And one of the points that we have made in our contribution for the Attorney General's consideration is that this is going to be a very costly exercise, Mr. Chairman, for these NGOs. So when they have to go to court, or when a court decides to do X, Y, or Z, then they have a right of appeal, and they have to find money to go to the court. So what we are saying, Mr. President, Mr. Chairman, is that this provision in 10 ought to be the responsibility of a tribunal.
Okay. All right. So
That's the point we are making.
Senator Vera had comments.
Thank you, Chair. The Registrar General is the last phase in a number of different possibilities that may take place, according to my reading of this section. And above what's here, even if someone is convicted or found guilty in one court, that process could go all the way up to the Privy Council. And none of these things here, I think, are objectionable for a nonprofit organization being struck out. But interestingly, it doesn't say the Registrar General shall cancel the registration. After all of these things, any one of these things occurring, he still has a discretion and can allow you to continue on the register. So,
Attorney General.
I thank Senator Vera for the calm, dispassionate response to that, and I thank Senator Mark for his inquiries.
Okay. So, honorable senators, the question is that clause 10 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable senators, the question is that clause 10 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 10 as amended now stands part of the bill. Before we move on to the next clause, honorable senators, the time is now 5:31, and it's a good time to take the tea break. Therefore, this House will now stand suspended until 6:01.